President of the session, Dr. G.B.Reddy, the Principal, University College of Law, Chief Guest, Professor S.K. Mahmood Sir, Vice Chairman, State Council of Higher Education, Professor B. Vijayalakshmi, Dean, Faculty of Law, Osmania University and Head, Department of Law, Osmania University, Dr. Aparna, Associate Professor, and among the audience, number of teachers, learned professors, organizer of this event, Dr. Ratnakar Rao, the other faculty members, dear students from University College of Law and other affiliated colleges. At the outset, I extend my warm greetings to all of you on the occasion of the Legal Services Day, which commemorates the coming into force of the Legal Services Act 1987 in the year 1995. In fact, holding and commemorating events like this is very much essential in order to understand the roots of this very important socio-economic issue, which is facing number of challenges in our day-to-day life. All of you are law students. You are familiar with the principles of natural justice. You know about adi alteram partem. You say that no person shall be condemned unheard. So when we are talking about legal services which are to be provided to any interested person, we are following this principle of natural justice, the principle of fair hearing. The second important point is that this concept of legal services, which ultimately culminates in the form of legal aid, is not something new. It has been recognized from the time immemorial in every nation, in every legal system, in every religion, including even the Gram Panchayat and Caste Panchayats. You come across the rule that every interested person must be represented by a legally trained person, whether he is formally trained or informally trained. Therefore, what we are celebrating today is nothing but an age-old tradition which requires rejuvenation in modern times. I don't know whether the students of University College of Law have climbed down the stairs from behind. You come across two rooms. Outside the rooms, you come across two boards. One is Pre-Legal Aid Center. Our old students are smiling. Pre-Legal Aid Center. One is sponsored by Metropolitan Session Judge. The other one was by Hyderabad District Legal Service Authority. Room number 1 used to host that. Now we also have the Family Counseling Center, the board outside the main entrance. These are some, in fact, simple steps taken by the college in association with the various LSAs, Legal Service Authorities, namely the District Legal Service Authority and the Metropolitan Legal Service Authority. And that imposes an academic social responsibility on the students to expose themselves to the practical aspects and to do their might in spreading legal awareness, in facilitating legal services, not providing. In fact, they are ill-equipped to provide legal services on their own. They have their own limitations being students, but they can work as catalysts. They can coordinate with the concerned legal service authorities, courts, sometimes panel advocates or civil society organizations. For instance, with regard to environmental protection, one of our famous environmentalists, Professor G.B.Reddy, he encouraged at least 4 or 5 law colleges, including one or two private law universities to file PILs through the, in fact, participation of the students to address some of the important issues. All of you are aware, Shreya Singh's case. Today everyone talks about, striking down of Section 66A of the Information Technology Act, which was not noticed by many police till another Supreme Court directive was given. That's a different issue. But who is Shreya Singh? She was a student, law student, like any one of you. So this is your way of providing legal services. In a small way. One need not file a public interest litigation. A small advice would do. As simple as that. And as far as the history of legal aid movement or the movement towards providing legal services is concerned, at least in recent times, you can go back to 1850s. As far as India is concerned, we always refer to Justice P.N. Bhagwati and his contribution. And another person by the same name, Justice M.M. Bhagwati in 1950s. We talked about Justice V.R. Krishna Iyer, who emphatically said, providing legal services is not charity. It should not be confined only to the four walls of the court. It is an obligation on the part of the state. Framers of the Indian Constitution also recognized the need to provide free legal aid. At the same time, they have not specifically included the same in the Constitution, though they provided under Article 22 right of an arrested person to consult a legal practitioner of his own choice. 39A was missing at that time. Article 39A, which speaks about equal justice and free legal aid, came into our Constitution only in 1976 by virtue of 42nd Amendment. Many people are very fond of criticizing emergency of 1975. I always look at the brighter side of emergency. 42nd Amendment has introduced some wonderful changes in the Indian Constitution. That is, constitutionally speaking, one of the important inclusions has been Article 39A, apart from the fundamental duties and many more. And in spite of the Constitution containing or not containing any provision or any obligation which is imposed on the state to provide legal aid or legal services to the needy sections of the society, those who are preparing for civil services, those who have written the general studies mains exam, you would realize that there is a direct question on legal services. Who is entitled to get free legal services? The working of NALSA, National Legal Service Authority, and its effectiveness. And I am saying this because even the lawmakers and those civil servants who are going to run the country, they are supposed to know about the importance of legal services. That is one example. Going back, if you look at the other laws in India, when we look at CPC, everyone knows we talk about indigent suits, indigent appeals, Order 33 and Order 44 respectively. We talk about Section 304 of CRPC 1973, which talks about amicus curiae. Everyone remembers Ajmal Kasab. If you open the internet and ask why should Ajmal Kasab be given legal aid, why is he not hanged immediately, you will find number of wonderful answers. Everyone knows the young man who killed more than 166 people, misguided person, doesn't matter. The entire world saw him using those firearms. In spite of that, he was given legal aid. Maharashtra State Legal Service Authority provided 2 lawyers to fight on behalf of Ajmal Kasab. Supreme Court appointed senior advocate Raju Ramchandran to represent Ajmal Kasab. You have to read that judgment. Of course, it's altogether a different story that the two Bombay lawyers who have not paid their fee so far. The State Legal Service Authority says they have not submitted their bills, and Raju Ramchandran, the senior advocate, refused to take any fees. That's a different issue. But the point is, who is entitled to legal aid? Suppose a person has committed a cruel offence, inhuman offence. Is he not entitled to legal aid? There was one case called Vijayawada Manohar's case. The fellow barged into a classroom, had the lady student with a knife, killing her on the spot. The State Bar Association, the concerned Bar Association passed a resolution saying that nobody will represent him before the court. But when in fact, the person was not given death sentence, ultimately there was an appeal. The High Court took cognizance of this, saying that however cruel the person may be, however vile, depraved, I am going to refer to one judgment of the Supreme Court, just about 3 or 4 lines. Still, the person is entitled to be represented by a lawyer. Legal services need to be provided. And same is the case with Ajmal Kasab. Justice should not only be done, it must clearly and manifestly appear to have been done. That's what India has shown. That's what Raju Ramchandran said while going to the Supreme Court. After completion of the argument, after the judgment was given by the Supreme Court confirming the death sentence, Raju Ramchandran bowed before the Supreme Court. Not because death sentence was awarded, don't mistake me, but because the kind of opportunity that was given to the accused person to defend himself. So he made a brilliant effort to save him from the gallows. Though many persons said, a senior criminal lawyer said, even 100 Ramjet Malanis wouldn't have saved Kasab from the gallows. Different issue. But as a human being, he was entitled to legal aid. He was given. That brings us to the basic principle that right to free legal aid is a human right. It is recognized as a human right through any number of international instruments, right from the League of Nations, through Universal Declaration of Human Rights, International Covenant on Civil and Political Rights. You can quote, you can Google, you will find more than 10 or 12 important international conventions which directly or implicitly recognize right to free legal aid as an important human right. That is one important aspect. And another important issue which I want to bring to your notice today on this particular occasion is that in the good old days, in 1950s, the judicial approach was very rigid, very strict. There was one case called G.B.Reddy versus State of Hyderabad, 1950s. The Supreme Court said that it is for the accused to ask for legal aid, legal assistance. If it doesn't, it need not be provided by the state. Remember, at that time there was no Article 39A, there was no Legal Service Authority Act 1987. But from those days, we have come to 1970s, 1980s. The students of constitutional law refer to at least 2 cases. One is M.H. Hoskote case. Another one is Subda's case. In both the cases, one was in 1970s, the other one was in 1980s. The court emphatically declared that it is the duty of not only the state, but duty of the judge also to ensure that every person who is charged is represented by a lawyer of his choice, if not a competent lawyer. That is very important aspect. That is the, in fact, moral of the story today. Yesterday I was talking to my good friend Irfan, and somewhere a mention was made by Justice U.U. Lalit. When we are talking about right to free legal aid, right, poor getting legal aid? Does it mean that the poor person is getting poor aid? Should it be an effective legal aid? It's like right to education. When we talk about right to education, we give statistics. So many people are formally educated. What kind of education is given? Same is the case with free legal aid also. Number of schemes. You have number of developments, entitlements and others. I think Nishit and the other speakers would take care. I don't want to make foray into their domain. But the fact remains that quality of legal aid also is equally important. Right? One of my PhD scholars who submitted PhD on presidential pardoning power, she gave an RTI application inquiring about certain data, and to my utter surprise I found that a person who was facing death penalty was given the assistance of a civil advocate having 7 years, who never appeared before a criminal case. Question is, what kind of legal aid or legal assistance do you get? A criminal advocate having sufficient experience can take care of the criminal trial, can effectively protect the rights of the accused or convicted in the case of appeal. But what about a civil advocate? Of course, there is no clear demarcation between civil and criminal, but experience counts. That is missing. Very unfortunately, that is missing. Of course, today you have this defense counsel system, which has been the brainchild of the National Legal Service Authority. We also have, I think, number of defense counsel appointed, directors and deputy directors being appointed. But I am yet to come across any success story as far as the effectiveness of defense counsel system is concerned. It's too early to say. It's hardly, few months old. And maybe, all of you can enroll yourself as part of that system once you get yourself enrolled. Then another important aspect, I will not take much of your time, is that in fact in 2012, a Delhi University professor, in fact National Law University Delhi professor by name J.S. Maan, Jeet Singh Maan, he conducted a wonderful research work. And the research work, I think the entire report is available on the web. Now they have Project 39A. You will get a whole lot of information on legal services. And there he found, because that was an empirical study and very comprehensive report, and just bringing to your notice a few important aspects regarding the availment of legal services which are provided by different legal service authorities, right from the Supreme Court, High Court, national, state and district. Right? And it was an empirical study confined only to the Delhi territory. Few observations, not many. And of course, one finding was that the beneficiaries approached the free legal aid services due to lack of resources to engage paid private legal practitioners. That's true. Because, I have been a member of this so-called team. I'm called a non-official visitor to Cherlapalli jail. I keep on going to jail, not as an inmate, as a visitor. I used to take some of the students, Ratnakar knows, during those days, 2004, 5, once or twice we have gone there. There I find a panel of 6 to 7 advocates. And when we ask the jail superintendent as to the availability, they say all the advocates are available, sir. I don't know the impact of availing such counsel. All of them may be good, some of them may be good, but we don't have any official data. Very, very few of them, I think, they are really representing. And the LACs, the Legal Aid Council, associate themselves to the legal aid services for getting experience and employment opportunity. This is a proven fact. Hypothesis was proved. Majority of them. Everyone may not be so passionate about providing free legal aid. Some of them may be really passionate, and I am not undermining their commitment. But most of them, they want to enroll themselves for the purpose of getting some kind of exposure, which might help them in their legal career. So you have, for example, the quality of articulation is just fair. So that needs improvement. The quality of arguments is just average. So these are some of the findings. Things may have improved. I'm quoting a data which is almost 12 years old. Now, be that as it may, I may also tell you about the Supreme Court's observation regarding the entitlement to legal aid. It may be in civil cases also. It may be in criminal cases. It may be even in tribunals. Even in tribunals. It may be even in departmental proceedings. Especially when the department is represented by a legally trained person. The delinquent officer also is entitled to get the benefit of the next friend or a legally trained person. In case of crimes, Supreme Court in Muhammad Rafi's case, A.S. Muhammad Rafi versus State of Tamil Nadu, this was a case where there was an attack on some of the police personnel in Tamil Nadu. Then local bar association resolved not to represent the accused person in the court. The matter went up to Supreme Court. Justice Markandeya Kaju, he made the following observations, which are very striking. Of course, he was quoting a judgment of the US Supreme Court. I quote, every person, however wicked, depraved, vile, degenerate, perverted, loathsome, execrable, vicious, or repulsive, he may be regarded by society as a right to be defended in a court of law, and correspondingly, it is the duty of the lawyer to defend him. This is a fact. Otherwise, Ramjit Malani, why was he called devil's advocate? Don't think that only Karan Thapar is called devil's advocate because of his program. Ramjit Malani. And in fact, in the same judgment, Justice Markandeya Kaju, speaking for himself and another judge, referred to an American lawyer by name Clarence Darrow. And the speciality of Clarence Darrow was that he used to represent only those persons who were wicked and loathsome. In the language which I have used, you can see. And he defended only those people, and ultimately he was known for the attorney for the damned. And he wrote a book also. It's called Attorney for the Damned. So it is the duty of everyone, every advocate, to defend any person who seeks or who is entitled to free legal aid. Then about the qualifications and all, like who should be enrolled, it is not for the Supreme Court to say, but in one particular case decided last year, the Supreme Court made few observations, Anoki Lal versus State of MP, where the court laid down certain norms. It says that where there is a possibility of life sentence or death sentence, learned advocates who have put in minimum of 10 years experience must be enrolled to defend the persons. In all matters dealt with by the High Court concerning confirmation of death sentence, senior advocates of the court must be engaged. This is to ensure that the quality legal service is extended, not to deprive the budding and in fact dynamic young lawyers who want to represent, but it's a question of life or death. This is one important aspect. Let's remember that even the advocates have a duty to render free legal aid, to take up pro bono work. And if you look at the Bar Council of India rules framed under the Advocates Act, they are clearly mentioned in your professional ethics viva. Some of the examiners might ask you, what are the duties of advocates towards the society? This is the duty towards the society, not only to make money, but also to provide legal awareness, to spread legal awareness, and also to take up pro bono work as and when it is necessary. Now to conclude, I will only say this much. Legal services are not the charge only on the lawyers. Lawyers are an important component. Law students play an important role, but it is for the judges as well, the courts. Sir was mentioning about the inadequate number of judges and inadequate number of courts. Ratio is 1:14. 1 million to 14. That means for 10 lakh people, 14 judges. Maybe it has increased to 18 judges. We need about 50. If that is the case, legal services will be adequately available. So governments also should think about it. It is not an yearly affair where we commemorate the event, remember and write in the exams very well. It must be translated into action. It is also the duty of the senior advocates, also the duty of, for example, when Harish Salve took 1 rupee for arguing the case of whom? Unfortunately, the gentleman died in Pakistan. What's the name of the, one Sardarji who was sentenced to death, and the matter was argued, before the International Court of Justice. Remember? What's the name? Kulbhushan Jadhav case. It is the responsibility of senior advocates like that. And so is the responsibility of the other advocates, the state. I once again, feel that we have rekindled our commitment towards providing free legal aid and free legal services in the years to come, in the days to come, and let us once again commemorate the Legal Services Day. I thank all of you, the learned, respected professors on the dais, off the dais, and all the students present here for a very patient year. Thank you very much.